Hello, and welcome to the State and Local Legal Center's Supreme Court Preview Webinar. I'm Lisa Soren with the State and Local Legal Center. Thank you to NACo for hosting this webinar. A few housekeeping matters before we begin. By email, you should have received the speakers' buyouts and a couple of handouts. If you want to ask a question, you can type it in the chat box. I will ask questions of our panelists at the end of the webinar. This webinar is being recorded and will be made available online on the SLLC's website and NACo's website as well. If you have technical difficulties, please put them in the chat box and our organizer will respond. The views expressed in this webinar do not necessarily reflect the views of NACo or the SLLC member groups. The SLLC has organized this event. For those of you who are new to the State and Local Legal Center, the SLLC files amicus briefs before the U.S. Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local government. These groups and the SLLC's 2 associate members are listed on this screen. The National Association of Counties is hosting this webinar. NACo's vision is to strengthen America's counties. Its mission is healthy, safe, and vibrant counties across America. Now, I'm pleased to introduce our speakers. Sarah Harris is a partner with the law firm of Williams and Connolly. She is merits counsel in a case involving the Rehabilitation Act, which she will talk about today. Rick Simpson is a partner with the law firm of Wiley. He is in the process of co-writing the SLLC amicus brief in another case involving the Rehabilitation Act, which he will also discuss. Ken Jost is the author of Supreme Court Yearbook and Joust on Justice. Sarah, you may begin with discussing your 3 cases.
Well, thank you so much, Lisa, for the invitation. It's always really fun to speak with this group. And I will say one observation about the term in general is that I do think there are a fair number of cases this term of pretty keen interest to states and local governments. And I'm really excited to get to talk about a couple of them. I will also say I am not leading with the sort of headline cases of this sort of guns, God, and germs docket, as I like to call it. We'll talk about that later, but there is plenty to be excited about this term beyond just sort of the headlines you might have seen. So I'll kick off with one of those cases, which is CVS Pharmacy Incorporated versus Joe. And as Lisa mentioned, full disclosure, I am one of the counsel for CVS in this matter. So I'm pretty much confining my discussion to what you can find in briefs. The argument hasn't been scheduled yet, but it will likely be on the December calendar. So why is this case exciting and interesting for states and local governments? Well, it's an interesting and important question under the Rehabilitation Act, which is a statute that's sort of a predecessor to the Americans with Disabilities Act, and specifically about Section 504, which is the operative provision in the Rehabilitation Act that prohibits various adverse actions and discrimination if they are taken, quote, solely by reason of a person's disability. And the Rehabilitation Act has gotten, I would say, more play of late because the Affordable Care Act expressly incorporates the enforcement mechanisms of the Rehabilitation Act and several other anti-discrimination statutes and extends those statutes to, say, insurers involved in the Obamacare exchanges, other actors in the health system. So the question in this case is, does Section 504 of the Rehabilitation Act extend to prohibiting policies that are facially neutral but have a disparate impact on individuals with disabilities? And CVS's answer in its brief, which was filed about a week and a bit ago, is no. Disparate impact liability is not covered under the text of the statute. And there are really sort of 3 main textual reasons that the brief outlines for that position. First of all, the Rehabilitation Act is actually one of the rare statutes to require that discrimination or adverse actions have to happen, quote, solely by reason of the person's disability. And I had flagged that language earlier, and it is something that features a lot in the brief because it is an unusual standard. Solely by reason of means that is the one reason, not other reasons. You've ruled out other reasons too. And so one of CVS's main arguments is that by looking to whether disability was the sole reason for discrimination, it wouldn't really sort of make sense to think that the statute encompassed facially neutral policies that might have a disparate effect for many different reasons, not just solely by reason of disability. Second of all, another textual reason is that this language is very similar to language in Title VI, which is a federal funding statute that prohibits discrimination on the basis of race. And the Supreme Court has already said that that statute does not cover disparate impacts, does not have a private cause of action for disparate impacts. And the third sort of textual argument in the brief, one of the main ones, is that the Americans with Disabilities Act does spell out really detailed protections for people with disabilities, and that reading in disparate impact liability into the Rehabilitation Act would actually create some mismatches with the fairly elaborate scheme that the Americans with Disabilities Act creates, including to cover some things that are disparate impacts. And then the CVS brief also covers some policy arguments, including that the plaintiff's claim in this case, which arises, which concerns the terms of a health plan, would render a lot of health plans unworkable because people with unique medical needs can always claim that they might be better off with something that their plan doesn't cover. And it would be very hard for people to sort of, at the front end, create a plan that would be facially neutral as to all conceivable groups of individuals with disabilities. One other thing to flag about this case, I will say there are 3 amicus briefs that I think will be of keen interest to this potential audience. One of which, of course, has Lisa on it as a counsel. It is the brief filed by the National Conference of State Legislatures and many other groups, including school boards and mayors groups. It's a terrific brief. I'm not just saying that because of the audience, it actually is excellent. And it makes sort of a really important threshold point, which is that the Rehabilitation Act is a federal funding statute. And that when you threaten states, I'm sure I don't need to tell this group this, but when you threaten states and local governments with the loss of federal funding based on allegations of disparate impacts from facially neutral policies, it would have a huge impact, a real chilling effect from plaintiffs, as well as a chilling effect from potentially the federal government. And that's sort of the nuclear option of threats in some ways, I think this brief is saying. And it's really unnecessary to hold out that sort of grave of a form of consequence because many other federal and state statutes already accomplish the type of protections that the plaintiffs are arguing for in this case. And so it would be strange to read this sort of disparate impact liability into the Rehabilitation Act when a lot of other statutes do provide for disparate impact liability, but also include a lot of guardrails that cabin the scope of that liability. So 2 other briefs to flag. One is by Louisiana and a host of other red states. That brief also sort of covers the idea that because the Rehabilitation Act applies to recipients of federal funding, it covers virtually everything that states do. And if the Rehabilitation Act includes disparate impact liability, states will have an unworkable situation trying to do cost-benefit analyses and trying to assess, whether a particular or neutral policy will expose them to liability. And Louisiana says that is not a tenable state of affairs for states. Finally, the District of Columbia and nearly a dozen, or maybe even more than a dozen, blue states filed in support of neither party and argued that CVS should probably win on any disparate impact claim on the facts. They simply asked the court to not foreclose disparate impact liability writ large. So you might have noticed missing from that list is the federal government. We will see what they do. If they want to file on the other side, their deadline will be in a month and a bit. But that's the case. The respondent's brief hasn't come in yet. So of course, respondents will have a lot of rejoinders to all of these points. But hopefully what I've said suffices to at least signal that this is certainly a case that a lot of states and localities seem to be watching pretty closely. All right, so my next case is Houston Community College System versus Wilson. There are some cases the court grants review of because you suspect the justices feel like they have little choice because there is like an overwhelming circuit split and there's just disparate outcomes in different circuits, and that's just no way to run a legal system. But there's also some cases that get granted because you suspect the justices thought they were just too cool not to take. And this case emphatically falls in the latter category. It has really unusual facts and a fascinating but pretty narrow First Amendment question presented. So the background of this case is that the respondent was elected to the Board of Trustees of Houston Community College after a very contentious election, and at least from the briefing, what sounds like a fairly sort of contentious state of play in the community college system in Houston. There are all sorts of allegations on both sides as to whether there are management issues, there's alleged bribery, it really sort of has everything in the backdrop. In all events, after becoming elected to this body, which is sort of a legislative type body that, you know, like most trustees of college systems, sets rules and manages this system. Respondent was, I think he was certainly very, 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 very critical of his fellow board members, not just in meetings, but actually going so far as to publicly criticize them on a lot of websites, filing lawsuits against them, doing all sorts of things of that ilk. And the rest of the board ultimately voted to censure him for this speech, and to censure him by expressing disapproval. The effect of that was that he could not be an officer, but he retained his position on board until he subsequently lost an election. And he didn't get certain travel expenses, he alleges. So he sued, claiming that the board had taken a retaliatory action against him in violation of the First Amendment. So this case is super cool because the question is a censure action the kind of governmental action that counts for First Amendment retaliation purposes? And so it gets into the history of censuring by the federal government, by the House of Representatives, in the Senate, and by state and local bodies. And I find it really cool. And I think the brief is really, at least petitioner's brief, which has already come in, has a really lot of really interesting anecdotes about the history of censure motions. And petitioner's basic theory is censures are not adverse actions for purposes of First Amendment retaliation. They are the official rebukes of a legislative body. They're saying, we don't like what you did, but they are not sort of the kind of First Amendment retaliation actions that usually constitute adverse actions. They really have effect only with respect to being the judgment of a body that you did something bad. And they say history proves this because there's a lot of common law history, including people who were imprisoned or expelled from the English Parliament for speech outside of official proceedings. They go way back into sort of some 17th century anecdotes. If that is your thing, you'll probably like this brief. But they also sort of tie this into more modern debates about what counts as government speech. Is this sort of pure government speech, so it's fine? Is it something else? It's really neat. And then respondent's position is sort of coming back. The brief hasn't been filed yet, but the gist of their brief in opposition is, yes, legislative bodies, of course, can censure members, but censuring is usually for conduct that happens inside the legislative session, or at least happens outside the legislative session, but is really connected to the work of the legislative body. And here, respondent is saying he was just criticizing people. It didn't really relate to the work per se of the trustees. And I think respondent, at least from the cert stage briefing, seems to be sort of carving out some sort of sense of germaneness of the censoring. It can't be for unrelated conduct or speech. So I think this case will really end up being a really interesting battle of line drawing, because I think everyone does agree, at least my sense from the paper so far is people seem to agree that there might be some category of censure that might not trigger the First Amendment, but where the line falls is an open question. So I think the court will have fun with it, and I think it will be a fun argument. All right, third case I'm covering is Gallardo versus Marstiller. This is a neat case. It's probably going to be argued in December, and it's sort of the classic clash of statutory interpretation principles that the court really likes to take. This actually does fall in the category of cases I think the court felt like it had to take. There is an incredibly defined circuit split. The 11th Circuit split with the Florida Supreme Court. So literally different rules apply depending on whether you're in state or federal court in the exact same place. And not only that, there was a circuit split between the 11th Circuit and other federal courts of appeals. And so that's kind of like, you know, a full house sort of in poker terms for Supreme Court cert petitions. And on top of that, Florida agreed that the Supreme Court should hear the case. So I think when people saw this petition, the sense was this might well be an auto grant. The technical term, of course, when we're in the court is very, very likely to grant something. And the issue in the case is, as I said, sort of a neat statutory interpretation question under Medicaid. So it is, can states that paid for medical care under Medicaid for past medical care recoup some of that money by seeking money that patients receive from a settlement that sort of lumped together past expenses and future medical expenses in one sort of settlement? The petitioner says no. Once it's sort of in that bucket, that the Medicaid statute sort of has a set of interlocking provisions that petitioner reads to say, no, you cannot take the money out of things that are earmarked for future expenses. Florida says, yes, yes, you can. And I think it'll just be, again, like one of those neat sort of meat and potatoes cases where the court is looking very carefully at sort of warring the canons of statutory interpretation and trying to make sense of what is a fairly complicated but important statute about how Medicaid reimbursement works. Another interesting feature of this case, just to flag very quickly, is that Florida isn't fully defending the 11th Circuit's reasoning below, which largely rests on the presumption against preemption, which is arguably a presumption that the court is sort of less fond of, I will say, these days, but is instead sort of sticking with the sort of straight up statutory text arguments. So there's no merits briefing from either side yet. So this is just what it's possible to sort of glean from the cert stage papers, but it should be a really, really interesting case if you like the sort of traditional down the middle statutory interpretation cases. It's not super ideological, it's just a really interesting case.
Thank you, Sarah. So before Rick discusses his cases, Rick or Ken, do you have anything to add to Sarah's cases? Anything you'd like to talk about related to them?
Not here. No, thank you.
No, other than it is interesting, the CVS pharmacy case that Sarah's handling does in some ways overlap with the Cummings case we'll talk about in terms of the fiscal impact on state and local governments and the importance of it in that respect.
So on that note, Rick, feel free to transition to that discussion.
All right, Cummings versus Premier Rehab Keller. As Lisa mentioned, we're working with her. Wiley is working with her on an amicus brief in this, and also the University of North Carolina School of Law Supreme Court program that I teach with Professor Andy Hessick is working on it. Key facts, it's an important case and a really interesting case with major implications. Basic facts, the petitioner, Ms. Cummings, is deaf and legally blind. She uses American Sign Language. Premier Rehab is a physical therapy provider in her local area. She alleges that Premier Rehab refused to provide her with an ASL interpreter. And as damages, she didn't allege any she got therapy from another provider, no evidence that she suffered any pecuniary harm, simply the fact that she couldn't use Premier Rehab, which she wanted to use and which she alleges had an outstanding reputation in the area. So the only damages that she sought were emotional distress damages under the ACA, the Rehabilitation Act. Key precedents here, both of these acts incorporate the remedies under Title VI. In the Barnes case, which is cited here back in 2002, the Supreme Court held that punitive damages are not available under Title VI. Basically, the analysis, it started with what's the relationship here? What's the basic basis for liability? The notion is that recipients of federal funding, in essence, agree, they do agree to comply with various anti-discrimination laws, among other things, as a condition of taking federal funds, which makes the relationship with the federal government akin to a contract, with one of the contractual promises by the recipient being that it will comply with discrimination statutes. The court in Barnes took a look at the nature of contractual relationships and the liability under contracts for breach, and noted that punitive damage awards typically are not allowed in breach of contract cases, and also noted that they're unliquidated in nature and and can be unpredictable. As noted here, the 11th Circuit later held that emotional distress damages are available in this kind of case, and went off the notion, really focusing on whether they are potentially available under breach of contract theory. And I think one of the interesting things about the case, and the petitioner's brief has been filed, respondents has not, but for the longest time before the Fifth Circuit decision in Cummings, that is the one that gets us here, Cummings created the circuit split by holding that emotional distress damages are not available. But before that, there were probably something along the lines of 40 cases that had allowed recovery of emotional distress damages without ever discussing the issue or analyzing it, just assuming they were available. And there were even a couple of Supreme Court cases that, at least by implication, appear to be authorizing these kind of damages, but no real analysis. And then the Fifth Circuit came out in a different way in this case. So the issue presented is whether the compensatory damages available under Title VI and the statutes incorporating its remedies include compensation for emotional distress. And it's particularly important, as I said, because that principle will apply to a number of different statutes. As I said, most cases have assumed they're available without analysis. The key issue confronting the court, I think, is how does Barnes apply here? How do emotional distress damages compare to punitive damages? One of the arguments is that emotional distress damages are not traditionally available as a remedy for breach of contract. There's a narrow exception for certain personal service type contracts, but as a general rule, you can't get emotional distress damages. And that also, much like punitive damages, the emotional distress, it's subjective, it's unliquidated, it's unpredictable. And as I noted, the decision on the case could have far-reaching implications since a number of statutes do incorporate Title VI remedies. So it will be an important one to keep an eye on. There were multiple amicus briefs in support of petitioner. I anticipate there'll be several amicus briefs, including ours, in support of the respondent. So it'll be an interesting one to watch. Okay, the next one I want to talk about, another kind of interesting and unusual case is City of Austin versus Reagan National Advertising of Texas. Going on to the key facts of this one, has to do with off-premises versus on-premises signs. The issue has to do with what kind of regulation can government impose upon signs. Here, the City of Austin defined an off-premise sign. It's quoted here, the definition is important. Advertising a business person, activity, goods, products, or services not located on the site where the sign is installed, or that directs persons to any locations not on that site. So that's the definition of an off-premises sign. At least in the version of the regulation, the statute, the ordinance that's at issue here, there wasn't a definition of on-premise, but it is implied from the definition of off-premise. Now, the ordinance also allowed an exception for signs that were grandfathered in, so to speak, as non-conforming signs. But if the owner of the sign wanted to change it and the change would make it substantially more non-conforming, that was prohibited. And here, what was happening is that Reagan wanted to take its standard non-digital sign, turn them into digital signs. And the City of Austin said, no, making it digital would make it substantially more non-conforming, and you can't do that under the ordinance. So the procedural history is that, as I said, Reagan challenged the ordinance, basically alleging that this distinction between on-premise and off-premise is a content-based regulation of speech. The district court found that it was not facially content-based, applied intermediate scrutiny, and upheld the regulation. The Fifth Circuit, again, I seem to have the Fifth Circuit cases today, and once again, they disagreed. They found the ordinance was content-based, and because it was, they held the strict scrutiny applied was applicable, and then on that basis held that the regulation was unconstitutional. The issue presented really, the issue has to do with interpretation of the Reed v. Town of Gilbert case. That's been, some have thought that case made a sea change in the law in this area. Others have thought not so much. As we'll see, there've been a number of cases interpreting it. And I think the key thing that will come out of this decision is how should Reed be interpreted. In Reed, there was a sign ordinance that prohibited outdoor signs, but it had multiple categories. It was more than 20, as I recall, a bunch of categories of signs. It prohibited outdoor signs, but with certain exceptions. And the exceptions included political, ideological and temporary directional signs to a qualifying event. And then there were various restrictions and regulations that applied to different categories of signs. The Supreme Court held that the ordinance was content-based because it turned on what the substance of the sign was, what it said, and on that basis applied strict scrutiny and held that the ordinance was unconstitutional. The key precedent since Reed, I mentioned there have been a number of cases talking about it. This Sixth Circuit case, Thomas versus Bright, held that, again, that a regulation concerning off premises, that kind of distinction was content-based because a government official has to read the sign to determine what it means, the function and the purpose. And then there are a couple of circuit decisions that with somewhat similar facts found, or analogous facts, found the regulation not to be content-based. We've got the DC Circuit there that dealt with event-related signs. And then the Third Circuit sign, which again, decision, which again went to the on-premise, off-premise distinction, but found that it was not content-based, that in fact, the application of that statute in on-premise versus off-premise could be ascertained without getting into a determination of the content. Sort of the considerations and implications, a pretty broad base as listed here. The Highway Beautification Act has some language that's similar to on and off premises. 2/3 of states use that kind of distinction to regulate commercial billboards. Numerous cities and localities use that distinction. So the holding here could be quite significant in terms of the implication for efforts to regulate signs in both the aesthetics and other aspects of that. And so it's definitely one to keep an eye on in that respect. The other notion here, the Metro Media case that's cited, could be a basis for the court to resolve the case on narrow grounds that really wouldn't address this, the on-premises, off-premises kind of central issue presented. The United States and the SG in their amicus brief suggested this as a possible way to resolve the case. This is a 1981 case that's never been overruled. Reed did not overrule it. That held that off-site commercial billboards can be prohibited while on-site commercial billboards are permitted. The Austin regulation goes beyond simply commercial matters, but the particular entities involved in the case, clearly it was a commercial billboard. And so this might be a way the SG has suggested to resolve the case without reaching those broader questions we talked about. All right, the last of my third is Carson versus Macon. Another really interesting case dealing with the religious freedom issues that the court has grappled with a number of times in recent years, and then of course are very high profile and get a lot of attention. This one has to do with Maine's tuition assistance program. Maine, yeah, I'm from New England, not Maine, so I know how rural Maine is, and it has a number of school districts that actually do not have a public secondary school, high school type level school, and mostly it's just because there aren't really enough students to justify that. And so what Maine has done is to adopt a tuition assistance program where for students who live in one of those districts that does not have a public school, they can get a tuition grant from the state to attend any public school in another district or any approved private school. And so basically the state will pay the tuition up to the maximum for students to attend a private school or another public school. The private schools involved here are Temple Academy and Bangor Christian schools. They are not approved schools. They've been excluded because they've been determined by Maine to be sectarian. They're Christian schools, fundamentalist Christian type schools. They have codes of conduct. The factors listed here have to do with the considerations that go into effect in terms of determining whether a school is sectarian or not. And suffice it to say, these schools are by any definition sectarian. They pride themselves on integrating religion into all aspects of the school. The petitioners here, two sets of parents who wanted to enroll their daughters in Temple Academy and Bangor Christian School, and alleged they couldn't afford to do that without the tuition assistance. So that's kind of the basic setup of the case. The issue presented is whether a state violates the religion clauses or the equal protection clause by prohibiting students who are participating in an otherwise generally available student aid program from choosing to use aid to attend schools that provide religious instruction. So kind of and as you might expect, there's lots of amicus interest in this case, lots and lots of amicus briefs filed. The key precedents that have to be applied here, two Supreme Court decisions, both within the last 4 years. Trinity Lutheran, which was a case that held that the state violated the free exercise clause by excluding a church from participating in a reimbursement program available to nonprofits regarding installation of recycled material playground surfaces. So basically the issue was whether the church was eligible to, church entity was eligible for this reimbursement program for playgrounds. And then more recently, just in 2020, the Espinoza case, which actually came down while the First Circuit was considering the case, this case that's up now, which held that the Montana program that excluded private schools from tuition assistance program violated the free exercise clause. Got a little tied up there, but the basic issue in that case had to do with a tuition assistance program. But that case expressly left open the issue here, which has to do with the distinction between use of government funds and the status of the entity. The court held that in the Montana case, the exclusion of the religious institutions stem from their status and not the use to which they would place the money. So procedural history here, the First Circuit upheld the exclusion, held that Maine's program complied with the Constitution. It noted that the court, regulation rather, or statute doesn't prohibit students from choosing to attend religious schools, and that it only prohibits students from using aid to attend schools incorporating religious instruction. So it really focused, not surprisingly, on this distinction between status and use that I mentioned was expressly left open in the Espinoza case. So it's an issue you knew would be coming up, and it came up very quickly in this case. Considerations and implications. As I said, the key issue is what about the distinction between status and use? And if use is treated differently, what is the level of scrutiny that applies, and how broad is the definition of free exercise? Really big picture issues, as you would expect in this kind of case. The First Circuit, as I mentioned, did a very detailed and I think thoughtful analysis of the issues in reaching its conclusion, and there is widespread interest in it, but number of underlying principles or implications, including access to public funding and religious education, inclusivity. One of the issues in the background is that the schools in question here, the religious schools in question, both in their employment practices and otherwise, discriminate, so to speak. They have religious views regarding, for example, not hiring homosexuals and other practices that are part of the background of the case, and that part of infusing religion into their teaching, which, as I said, is something that they expressly do in all respects, and also involved is the parental rights issue, the ability of parents to choose where they would like to have their children educated. And as I said, it's really unclear how it's going to be a significant decision in all events, but depending upon how the court decides to resolve it and how it writes it up, it could be more or less significant with respect to issues beyond those directly at issue.
Thanks, Rick. Before we transition to Ken's cases, Sarah or Ken, do you have anything that you would like to add to any of Rick's cases?
I just have two quick, sorry.
Not from me, thank you.
I have two quick observations. One is with respect to City of Austin. One other interesting question, just beyond the signage issues, is whether Reed is actually confined to signage or extends more broadly. I mean, the interesting thing about Reed versus Town of Gilbert is that it is obviously purporting to set forth a test for how do you tell if a regulation in general is content neutral or not. And the fact that it came up in the sign context in some ways maybe made it easier for the court to grapple with it. But a lot of courts, I think, since Reed have tried to kind of cabinet as a rule about signs or billboards. Right. And I think one of the interesting open questions the court may not have to deal with here, because it has also taken another case about signs, is simply how to integrate Reed into the rest of its First Amendment jurisprudence. Because I think Rick is spot on to say, if taken seriously, Reed is a hugely, like probably the most important case of like the OT 14 term, and like that was the term of Obergefell. Like this is a huge doctrinal case in First Amendment terms, because it really changes, I think, the understanding of what content neutrality means. So has like profound consequences for many, many, many statutes. But the court really kind of hasn't done that work yet. So this could be a actually like quite an important case, even though it sounds like it's just about signs. I'm not so sure that's right. And second, just an observation about Carson. I think it's one of the first cases in which Justice Souter, sitting on the First Circuit,
yes,
is having one of his opinions. He didn't author it, Judge Barron did, but is having one of his opinions reviewed by the Supreme Court. And I think that also just kind of sets up an interesting dynamic with respect to Justice Souter's sort of jurisprudence on the court and where he sort of landed. I think it's a very different era, even if you look at when Justice Souter wrapped up on the court versus where the court is now on the free exercise clause. And the COVID emergency cases, I think, have also helped the court develop a little more of its free exercise jurisprudence in a way that may well bear on sort of the what may well be the end of a trilogy of cases in this particular area on sort of school funding type issues. And I think the court does seem closer and closer to sort of saying non-discrimination is a rule. It is a very absolute rule. You cannot necessarily you can't disfavor any type of exercise of religion, whether it is status or use. So at least that's the conventional wisdom, but we'll see if that's right. Who knows?
So those are great points, I think. And I will say, when I saw that Justice Souter was on the panel, my thought was, wow, it seems long ago and far away that he was on the court.
I think that was true of Caniglia last term as well.
That might have been true.
That he was involved in that case as well. I don't know if they've ever reviewed an O'Connor decision, because she's definitely issued a few in her day since she left the court. Anyway, let us now turn to Ken, who's going to cover a couple of controversial cases on the court's docket.
Okay.
Anytime.
You want to start with the Mississippi abortion case? Presumably everyone listening knows that it's 48 years ago that the Supreme Court established a woman's qualified right to an abortion during major portions of a pregnancy. That case is called Roe v. Wade. Mississippi enacted a law in 2018. You see the code citation there. The title is the Gestational Age Act, that prohibits an abortion after the 15th week of pregnancy. And that runs afoul of the Roe v. Wade standard, which is that the state cannot impose a complete ban on abortions before fetal viability, which is usually characterized as 24th week of pregnancy. Let me just note here, the Mississippi case is not the Mississippi law is not a heartbeat act comparable to the act in Texas, which prohibits an abortion after a so-called heartbeat is detected. The Mississippi law includes as a finding one of a somewhat long list of legislative findings, the finding that an unborn human being's heart begins beating by 6th week of pregnancy. But in any event, just let me, to make sure there's no confusion, this is not a heartbeat act. The issue, the Mississippi, a district court judge ruled the law invalid and prevented it from going into effect. The Fifth Circuit similarly, quite sternly said this law is unconstitutional because Roe v. Wade. And Mississippi filed a petition for certiorari asking the Supreme Court to review the Fifth Circuit's decision striking the law down. In that petition for certiorari, Mississippi posed 3 questions. One, the first question, whether all pre-viability bans on elective abortions are unconstitutional. The second question that the state asked the Supreme Court to choose between 2 precedents, the undue burden standard in Casey, which says any law, restricting abortions that results in an undue burden is no good. And the more recent case, Whole Woman's Health versus Hellerstedt from Texas, the 2016 case, in which the court per Justice Breyer balanced the state's asserted interests in various regulations on abortion clinics against the burdens that those regulations would impose. And Mississippi said, those 2 standards are in tension, so why don't you use this case to pick one or the other? Mississippi also submitted as the third question presented, whether abortion clinics have third-party standing to, challenge a law on behalf of their clients, their patients. And in granting certiorari, the Supreme Court limited this case to question number 1. So this is a very clean test of the Roe v. Wade viability standard. Can a state ban an elective abortion before viability? And any number of states are trying to do that. It's given, you can, handicapping this case is a perilous task, to say the least. 3 of the 3 junior justices were appointed by a president who promised that any justices he appointed would vote to overrule Roe v. Wade when the issue was presented. We'll see whether those three do. Lots of Supreme Court watchers can argue, oh, Chief Justice Roberts won't let that happen, or oh, maybe Chief Justice Roberts will. And so, the outcome is yet to be determined. In any event, this case, in terms of the assembly line, this case presumably will be argued in December. It's not on the October calendar. It's not on the November calendar, and it's in line to be argued in December. And I mean, it's a clear. It is the showdown that anti-abortion groups have been pining for when was Casey? Casey was 30 years. Casey was 30 years ago, right? And the court fell one vote short of overruling Roe v. Wade in the Casey case from Pennsylvania, and here we are 30 years later with an ideologically conservative majority seemingly poised to overrule at least part of Roe v. Wade. Mississippi includes in the law legislative finding that the later and later an abortion, the greater danger to the woman's health, physical and psychological, and the greater harm to the state's interest in potential life. And just to reiterate, in its petitions for certiorari, the state said it's not necessary to overrule Roe v. Wade to uphold our law. But in the state's brief on the merits, the state asserted explicitly, please overrule Roe v. Wade. And so we'll have to wait until after Thanksgiving to have this case argued. And there is one other abortion case that will be argued earlier that may not squarely join abortion rights issues. Kentucky passed a law that essentially prohibits the most common abortion procedure, the D&E abortion, dilation and evacuation, after 6 weeks gestation. And that case is now styled Cameron, Attorney General of Kentucky, versus EMW Women's Surgical Center, which is an abortion clinic in Louisville, Kentucky. And Cameron is the elected Republican Attorney General, elected in Kentucky's off-year election 2019. the case, the Sixth Circuit ruled the Kentucky law unconstitutional, struck it down in June 2020. In an earlier stage, the Sixth Circuit struck this down under the name EMW Women's Surgical Center v. Friedlander. Friedlander is the Democratic health secretary under the Democratic governor, Andy Beshear. Earlier, the case had been styled as EMW Women's Surgical Center versus Meyer, who was the Republican health secretary under the Republican governor. The Beshear was Attorney General for the Commonwealth of Kentucky, and Beshear was dismissed as a party in December 2019. And the case continued as EMW versus the health secretary. A week after the Sixth Circuit's ruling, June 2nd, 2020, if I've got the dates right. 1 week later, Friedlander notified the Attorney General's office, we're not going to petition for rehearing. We're not going to petition for certiorari. And Daniel Cameron, Republican, said, "Well, you mean you're just going to throw in the towel? Well, I can't let that happen." And so Cameron, within a matter of days, filed a motion to intervene, and included with the motion to intervene was a petition for rehearing. And a three-judge panel, a divided three-judge panel, said, "No, you can't intervene. You're a little bit late. You know, you knew that you were going to be Attorney General as of December 2019, and you've waited 6 months to try to get in this case. No, I mean, we rarely grant motions to intervene after we've made a decision, and there are a bunch of factors that bear on whether a motion to intervene is timely, and they all go against you, including the fact that, gee, you could have moved to intervene in December, and you didn't. And you're just too late." Cameron argued, I filed as soon as Friedlander told me he wasn't going to defend this case. And so the issue presented is whether a state's Attorney General may intervene in a case where no other state official is defending the constitutionality of the law at issue. You can see there, Kentucky law clearly authorizes the Attorney General to represent the Commonwealth in defending cases in which the Commonwealth has an interest. But of course, Kentucky law does not override the federal court's power to enforce its timeliness rules. And in the second panel decision telling Cameron, no, we're not going to let you intervene, the dissenting judge said, well, you know what? I think Cameron can take this case to the Supreme Court anyway. And Cameron did take the case to the Supreme Court. Petition for certiorari filed at the end of June, I think it was, and was granted. And so this case is now going to be argued on second Tuesday, October 12th. And again, the issue is whether the Sixth Circuit was right to say, I'm sorry, General Cameron, you waited too long and we're not going to put up with that. Let's see, Lisa, you want to show the two other cases that are in the pipeline? There are two other abortion cases in the pipeline, and significantly, each of those is brought in the name of the state's attorney general. The Missouri case and the Arkansas case. So there's no argument that nobody's arguing that Cameron has no interest in this case, but the argument will be whether the Sixth Circuit was right to say, I'm sorry, General Cameron, you waited too long, and so you lose. And we'll see what happens after argument on October 12th. Those two other cases, those two other abortion cases, both involve laws that, among other provisions, prohibit an abortion based on diagnosis of autism in the unborn fetus. And so both of those laws say, that is no valid reason. And if that be the woman's reason for seeking an abortion, the state can prohibit the abortion. And many years ago, I remember that a reproductive rights advocate explained to me, if the state says one reason for having an abortion is prohibited, if the state can impose that rule, the state then can inquire of every woman who wants an abortion. Why do you want this abortion? If you have a prohibited reason for seeking an abortion, we can stop you from having an abortion. And so these two cases present that legal conundrum, and my guess would be that the justices on September 27th will conclude, you know what, we've got enough abortion cases on calendar already, so we don't need to hear to either of these, even though they may present cert-worthy questions, but let's not take them up this term. And is that a cue to go to the New York gun case, the New York concealed carry case? So New York is one of the, New York, according to the National Rifle Association, is one of 7 or 8 very restrictive states in terms of granting licenses to carry concealed weapons outside the home. The majority rule, if I understand the NRA's map correctly, the majority rule is that about half of the states have laws that essentially say if somebody applies for a permit, grant it. And a bunch of other states don't require a permit at all. You can carry a weapon outside home without a permit. So New York law says that the licensing officer shall not issue a permit unless first finding that the applicant is of good moral character, no history of crime or mental illness, and that there is no good cause for denying the license. A separate section of the law requires the applicant to show affirmatively, quote, proper cause for the license. The New York State Rifle and Pistol Association is the listed plaintiff or the petitioner, and two individual plaintiffs brought the lawsuit, and one of them lives in Rensselaer County outside Albany. And he said, there's crime up here in Rensselaer County, and I would like to have a permit to carry a weapon to be safe. The U.S. District Court judge in Syracuse rejected the plaintiff's challenge to the New York law on the basis of a Second Circuit decision about 20 years ago. I mean, before the Supreme Court's Keller decision, and she held that, the Second Circuit's already. I'm in the Second Circuit, so I'm bound by the Second Circuit's earlier decision that I have to reject your suit, and she did. And the gun group applied for a petition for certiorari, and the argument in this case will be interesting to this extent. Representing the petitioner will be Paul Clement, a former U.S. Solicitor General, and presumably representing the New York Superintendent of Police will be the state's Solicitor General, Barbara Underwood, who was acting Solicitor General of the United States for a period of time while there was no confirmed Solicitor General. So it'll be, I've seen both of them argue many times. So if anybody wants to listen to a good argument, I recommend this when it's argued on November 1st. And I enlist several law students to assist me as interns, and I have told them, you'll want to listen to this one. There's two heavy hitters, and ordinarily I would tell my interns, and you should go watch. But in fact, general public is not allowed is still not allowed in the courtroom for oral arguments through December. So as full-time Supreme Court correspondent, I will be able to go watch, and maybe I will, or maybe I will listen, just as I listened all last year. And at least for the time being, the Supreme Court will be hearing arguments in the courtroom and live streaming those oral arguments via C-SPAN. So, and I mean, the gun rights and gun safety groups have squared off in this case, but the impact may be somewhat less than one might assume, given the NRA's description of state laws in general. As I said, New York, the NRA counts New York one of the 7 worst states in terms of gun rights.
Thank you, Ken. We're running a little short on time. So I'd like to see if Sarah or Rick have any comments on the cases that you're talking about. But before they answer, to those in the audience, if you'd like to ask a question, you may type it in the chat box at this time. So Rick or Sarah, any thoughts on Ken's cases? Oh, Rick.
Looks like Rick's on mute.
Sorry about that. I mean, you know, they certainly are the highest profile cases that are coming up this term, and controversial ones. I was looking at the docket on the New York State Rifle and Pistol Association case, and the number of amicus briefs is just extraordinary. And so they're both obviously, you know, lots and lots of interest. And as Ken said, going back to the abortion cases and the vote in Casey, it's anyone's, you know, guess as to where it will go, but it certainly is a very different court than it was when Casey was decided. So I think that is something to focus on.
So we have
Rick,
gotten.
let me be quick. Rick just reminded me that I had intended to note that the first amicus brief in New York in support of New York was filed just this week, and the friends who signed the amicus brief defending the New York law were Judge Michael Ludig, Stuart Gerson, Peter Keisler, and Carter Phillips.
Carter Phillips, yeah.
All of whom are card-carrying conservatives. And when Larry Tribe spotted that brief, he tweeted about it, and he called it a powerful, his word, brief. And the brief says, in part, the Second Amendment allows states to limit the carrying of loaded weapons outside the home. And we'll see how much weight that carries with this conservative bench.
So we do. Oh, sorry. Go ahead.
No, I'm just going to say I pulled the docket, and that one jumped off the page when I saw those names and coming in support of respondents.
So we do have a question from the audience, and it is whether there are any qualified immunity cases on the docket.
Real quick, and one other thing, in the Dobbs case, the no bottom side amicus briefs yet, but the list of briefs supporting the state is like this long, and presumably we'll start seeing some briefs from reproductive rights organizations challenging the state and supporting the abortion clinic that is, that brought the case.
So Sarah, I think you were going to answer about qualified immunity.
So the short answer is I'm not aware of specific petitions, although it's a perennial issue. And so there are sure to be some. I think it's like a great question because it's a perennially interesting part of the court's docket. Last term, as I'm sure many in the audience know, the court for the first time had some reversals of grants of qualified immunity and said you shouldn't have granted qualified immunity in these cases. That happens like approximately never, or at least like very, very rarely. And so I think there is a sort of growing sense that the court may well tackle qualified immunity at some point in the future. Why it's sort of denied a litany of petitions so far, I'm not sure. It is obviously an issue that divides the conservative justices. But I do think the court is probably getting pretty close to 5 to significantly constrain qualified immunity, at least a coalition between the liberal justices and conservatives. So stay tuned.
Did you want to add something?
Sorry, go ahead.
Rick,
No, I was just going to say that I agree with Sarah. I guess it was in 2019 that there were a raft of petitions, got a lot of profile, especially in the notion of it being a racially charged issue. And some of them were carried over, 4, 5, 6 conferences, and then ultimately they were all denied. So if you think, I get the sense it's an issue that they're going to grapple with ultimately, and there certainly is a lot of interest and scholarly commentary about changing the way the substance of the doctrine and/or the way in which it's applied, the way in which courts avoid deciding whether the action was constitutional by simply saying it's not clearly established, and then you end up never getting a determination. You never get a clearly established right. So it's definitely something that will be coming up.
So I'll end on this note. There is a very interesting petition out of the 10th Circuit involving, I think, Denver police officers who prevented someone or took their phone away from when they were recording police officers. And what's interesting is many Federal Circuit Court of Appeals had previously held that recording police officers didn't violate the First Amendment, but the 10th Circuit hadn't held that you have a First Amendment right to record police officers. So one of the issues in the case is whether it was clearly established as of 2014, which, as I assume the first time, a court of appeals said, yes, a person has a First Amendment right to record police officers. That's one question. The second question is this: the policy, I guess, of the Denver police was, it said, people have a First Amendment right to record you. And so the officers, apparently said they read the policy and they understood it. But regardless, they were granted qualified immunity because the 10th Circuit had never held that recording police officers was a First Amendment right. So I don't remember that case is in long conference or not, but it's not just like the interesting issue of, I think we kind of all would agree recording police officers is protected by the Constitution, but what does it mean for circuit court precedent to be clearly established if it's circuit court precedent, like not in your circuit? And then what's the merits of your employer saying this violates the Constitution, but no court has held that in your jurisdiction? So anyway, it's a great case to watch, very interesting. But at this time, I'm going to wrap up the webinar as we have gone a little bit over time. So I'd like to thank Sarah, Rick, and Ken for providing us with a lot of information about these interesting cases. Watch out for the cases that come out of the long conference in a couple of weeks. And I'd like to thank the attendees for listening in. And to everyone, have a safe, healthy, and wonderful rest of your day.
Thank you, Lisa.
Thank you.